Our next plenary session is the Establishment Clause that is going to be presented by Professor Sheldon Nahmod. He's a distinguished professor of law at the Illinois Institute of Technology, Chicago-Kent College of Law, and is a member of the Illinois and United States Supreme Court bars. He is a graduate of the University of Chicago, Harvard Law School, and Divinity School of the University of Chicago. He practiced law in Illinois, and as an academic, he has written many law review articles on Section 1983 and constitutional law, his principal fields of study and teaching. His 1983 treatise, initially published in 1979, was the first dedicated treatise exclusively to Section 1983. If you would, please help me welcome Professor Sheldon Nahmod.
Thank you, Scotty. Appreciate it. Good morning. I'm delighted and honored to be here. I've had connections with several New Mexico law firms for several decades now, and it's good to be among friends. I was thinking about how to make a graceful transition from Marcia Clark and OJ to the religion clauses. I'm not able to think of a way to do it. So what I am going to do is get right into my topic. My plan is to speak for an hour, give or take a little, and then open it up for questions. And I'm going to cover the basics of this controversial topic, both from a constitutional and a statutory perspective. And in order to do that, as many of you probably would agree, it's necessary to get into some political theory about religion and government, and some history as well. And for those of you who may be involved in civil rights litigation, I point out that violations of the Establishment Clause and the Free Exercise Clause may be actionable for damages under Section 1983, but the 1983 part is not what I'm talking about today. This is going to be a bit of a roller coaster ride, in part because of the somewhat troubled relationship between the Establishment Clause and the Free Exercise Clause, as well as because of the play between the constitutional provisions I'll talk about and the statutory provisions, RFRA and RLUIPA, not to mention the changing views of the justices of the United States Supreme Court themselves. So here we go. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That is, as you know, the first part of the First Amendment, and the rest of the First Amendment deals with speech, press, petition, and the like. And what may unite the different components of the First Amendment is that both religion and speech are tied to freedom of conscience and thought. At least that's my own take on it. Now, I'm assuming you have my outline in front of you, but whether you do or not, I will tell you as I get into this what my general subject is. And the first topic is the general purposes of the religion clauses. And here I have to mention the Enlightenment, which gave us the assumption that self-government depends upon reason and practical judgment, while religion, in contrast, depends on faith and passion. So what the religion clauses do in general is first protect the state from religion. The idea is to protect the state from the direct influence of faith and to minimize the effect of passion on, or religious passion, I should say, on government decision-making. The theory is that this adversely affects self-government by distorting it, by inflaming passions. Somewhat less often remarked on in terms of the purposes of the religion clauses is the goal to protect, the purpose of protecting religion from the state. This is not just direct interference we're talking about, such as preferring one religion over another, but also offering money to religion that may have an effect on religious belief and religious behavior. The power of the purse. A nice way of putting that is a concern with behavior modification. A not so nice way of referring to it is bribery, bribing religion. The purposes, or rather the specific ways we approach the religion clauses will tell us a lot about how we deal with particular cases. We've all heard of strict separation. And Jefferson and Madison especially were avid proponents of strict separation. The famous Jefferson letter to the Danbury Baptist Association in 1802 regarding this wall of separation, that powerful metaphor, and James Madison's memorial and remonstrance. The idea here is you keep the state and religion separate. The public-private distinction is inviolate. Keep religion out of the public square and government out of religion. These are separate spheres. And this strict separation approach is thought to protect both state, both government, and religion. Now, we've heard a lot about evangelicals in the last few decades, but there is a very famous evangelical from the 17th century, Roger Williams, who lived in Massachusetts. Roger Williams and many like him were strict separationists because in their view, the state and government were profane. Religion is sacred, and you don't want the two to mix. That's an interesting aspect of history that is all too often forgotten. So that's one approach to the religion clauses, strict separation. A second approach, which we've heard a lot about lately, but it goes all the way back to the founding, as so many things do, is accommodation. And here George Washington and John Adams were what we might now call accommodationists. They argued that self-government requires citizens with basic moral principles, and perhaps the best grounding for the establishment, the creation of such moral principles was religion. From their perspective, you protect religion in order to protect government. Notice that's a kind of instrumental approach to the protection of religion, and they're protecting religion in order to protect government. And what both of these positions have in common is a kind of neutrality. All agree that at the very least in this country, the religion clauses mandate that no one religion should be preferred over another religion. However, interestingly enough, some justices think that government can prefer religion in general over non-religion. And we're going to see this in a little bit when we talk about cases like Locke versus Davey and last term's case in Trinity Lutheran, as a matter of fact. So that's some of the historical and theoretical background. Let's dig in a little bit and talk about three very controversial areas involving Establishment Clause jurisprudence. Prayer, especially government-sponsored school prayer, But let's back up just for a moment. At its core, clearly, the Establishment Clause mandates that there is to be no government-established church. No government-established church. I think everybody agrees on that. It's also interesting as a historical note to observe that Establishment Clause jurisprudence really began in the Supreme Court after the Second World War. Our nation became much more religiously diverse, and religious minorities became much more confident. You will probably remember in the free speech setting how often Jehovah's Witnesses brought free speech cases and made so much of our free speech jurisprudence in the 30s and 40s and beyond. Now let's get into school prayer, specifically the famous, or in some circles infamous, decision in Engel versus Batali in 1962, which held that school prayer that is governmentally sponsored, students, I take it, can pray themselves silently, but it's when prayers are sponsored by the government in school that they pose a problem. And as we'll see a little bit when I get into the particular Establishment Clause tests, including the Lemon test, school prayer cases are actually very easy from an Establishment Clause perspective because they involve prayer, which is predominantly religious in purpose and in effect. So those are fairly easy, and the ease with which those cases are decided is accompanied by the fact that students are a captive audience. They have no choice. So that's school prayer. What about other kinds of prayer? What about legislative prayer? Way back when, in 1983, the Supreme Court came down with a very interesting decision in Marsh v. Chambers, which allowed the Nebraska legislature to have prayers led by a state-employed chaplain. The Supreme Court upheld that because of the unique history of legislative prayer. The first Congress of the United States hired a chaplain in 1789, 3 days before agreement was reached on the very language of the First Amendment. So that's Marsh v. Chambers. Now, a couple of years ago, the Supreme Court handed down a rather remarkable, at least to some of us, legislative prayer case. And maybe this is an issue for some of you here in New Mexico, maybe not. The town of Greece case involved this town, which was overwhelmingly Christian in New York State, which had over a period of a decade or so regularly invited Christian clergymen to lead the opening prayers in town board meetings. These clergymen, more often than not, invoke Jesus and or the Holy Ghost in their prayers, and typically everyone, including members of the public who were mostly adults in attendance on various business matters, was asked to stand, bow his or her head, or join in the prayer, which most but not all did. At the same time, the town, after protests from non-Christians, including several Jews, invited a few others, including non-Christian clergy, to lead the opening prayer, which was done for a very short time, say a few months, after which the town reverted to its past practice, primarily because the town's places of worship were all Christian, and also because it was easier. The Second Circuit found this violated the Establishment Clause. And I'll just read one sentence from that before I tell you what the Supreme Court did. What we do hold is that a legislative prayer practice that, however well-intentioned, conveys to a reasonable objective observer under the totality of the circumstances an official affiliation with a particular religion violates the clear command of the Establishment Clause. The Supreme Court, not surprisingly, granted certiorari and gave the answer to the Establishment Clause question that most of us, including me, expected and predicted. The 5-4 decision reversed the Second Circuit, and its reasoning is very interesting indeed. It's an example of the move towards accommodation in the last couple of decades. Justice Kennedy wrote for the court. He emphasized that Marsh case I told you about with its reliance on tradition, and he rejected the argument that Marsh was distinguishable because overtly Christian prayers were not involved there. This was irrelevant in Marsh, in his view, to the court's reasoning, and he disavowed dicta to the contrary in subsequent Supreme Court decisions. So the prayers here fell within the tradition of Marsh, and it was also important that the town maintained a policy of non-discrimination. There was an alternative ground about non-coercion in this case, but we don't really need to talk about that at this point. I want to tell you, though, that Justice Kagan wrote a very impassioned dissent arguing that Marsh was distinguishable because the prayer was explicitly Christian. In Marsh, the prayer was primarily for legislators. Here, the prayer was not only for local legislators, but also involved citizens present to conduct business. And finally, she chastised the majority's obvious blindness to other religions and their adherents, and its insensitivity, notice this is the legislative prayer, its insensitivity to what citizenship means. So that's Town of Greece, a fascinating case, not surprising, but one that completes the picture up to the present time of prayer. School prayer is still as it has been. In other words, violative of the Establishment Clause. Legislative prayer, things are happening there. So that's one hot area, prayer. And remember that school prayer decisions were handed down during the Warren Court. There were impeach Warren signs around at that time, not only because of this, but because of criminal procedure cases and the like. A second hot area is school funding. And notice the political issue of fairness in these school funding cases. If those parents who want to send their children to private religious schools get no state help whatever, even for partial payment, if you will, for the secular parts of the private education, those parents have to pay extra for that on top of the taxes they are already paying to support public schools. So at the beginning, there was a pretty strict separation in the school funding cases involving busing and the like. The court was very sensitive. We'll see more of that when we get into the different Establishment Clause tests. The court was very sensitive to making sure that money did not go directly to religious schools. And since money is fungible, even if you say you're giving money to religious schools for the secular part of the education, nevertheless, how are we to know, which gave rise to the entanglement test, about which more later. There has been a revolution. I think then Chief Justice Rehnquist began this revolution with respect to the Establishment Clause, so that what was once unthinkable, the possibility that vouchers given to parents for which they could use to pay both for public education and private education. The Supreme Court had slapped that down time and time again. That has changed dramatically, and now vouchers, the Zellman case, handed down in 2002, were, under certain circumstances, were of non-discrimination, were held constitutional. One of the important aspects of the reasoning in that Zellman case, allowing vouchers that parents could use for both religious education and secular education was, here as a former torts teacher, I enjoyed it, a kind of notion of superseding cause. The money is given to the parents. It's the parents who decide where the money goes. If they decide to spend it on education in a religious school, that's not the government's choice, it's their choice. So dramatic changes over the years, from relatively strict separation in school funding for private religious schools to allowing vouchers to be used to pay for private education that may be religious in nature as well as public. The third hot area, and it's intriguing, we were talking about school prayer a little bit ago, we were talking about money, but this third area shows you how important symbols are, not only in our society, but everywhere. For the longest time, religious displays were, if they were primarily religious in nature, were struck down as violative of the Establishment Clause, have a religious purpose, religious effect, and the like. Then we got, a little over 20 years ago, actually 30 years ago, we got Lynch B Donnelly. This was a publicly owned creche, which was accompanied by Santa and reindeer and the like, that was displayed on private property in a commercial district. The United States Supreme Court upheld this government display against an Establishment Clause challenge. The court, in an opinion by Chief Justice Berger, talked about the historical aspect of this, talked about acknowledging the celebration by large numbers of people in the community of this event, of this historical event, and this did not violate the Lemon Test. The purpose was secular in nature, the effect was secular as well, and there was really no entanglement. And because of this result, some of us came up with the reindeer rule of Establishment Clause jurisprudence. Government can get away with any religious displays, just throw a reindeer in there, and you're home free. But the more serious point about the reindeer rule is this, and Justice Brennan was in dissent. He was a devout Catholic. He said, look what you're doing. What you're doing in this case is watering down religion. You have commercialized and watered down the most sacred, well, one of the two sacred events in Christianity. What do you think you're doing? If you're truly religious, you don't appreciate this Supreme Court decision. Well, as we know, every year in the last 20 or 30 years near Christmas time, there is this so-called war against Christmas going on, and there are lots of cases that have come down. County of Allegheny was a two-sided decision. In one, there was a nativity scene inside a courthouse itself, and the Supreme Court struck that down. On the other hand, outside of the city-county building in Pittsburgh, there was a display which was called Salute to Liberty. And that display had a menorah, which was given, put up by Chabad, a Jewish religious group, and a Christmas tree. And you can guess, based upon my comments about the Lynch case, that the Supreme Court upheld the latter because it wasn't predominantly religious in nature. It was a salute to liberty. How about the Ten Commandments in the courtroom? Well, the McCreary County case struck down such a display. In contrast, in the Van Orden case, which was a companion case handed down in 2005 as well. The court there upheld a display of the Ten Commandments on Texas State House grounds. So what we have seen overall in connection with these three very hot and controversial areas is that in connection with funding and religious displays, a dramatic move in the direction of accommodation, away from separation, except for school prayer, which has held firm in terms of establishment, but now you've got legislative prayer that has recently arisen. Now, the Establishment Clause test, because quite obviously, implicit in my summary above is the use of various Establishment Clause tests that we now need to address. And this is not only for Establishment Clause purposes, but also for Free Exercise Clause purposes, also for RFRA purposes, and for RLUIPA purposes in a little bit. I mentioned the Lemon test. It goes back quite a ways to Lemon versus Kurtzman, and Justice Brennan wrote the opinion on that. It's the most government restrictive Establishment Clause test. It was then a three-part test. You look at what the government has done, and is the purpose of what the government has done primarily religious in nature. If the answer is no, then you move on to the next part of the test, which is effect. If the answer is yes, it's unconstitutional. In other words, each of these is in the disjunctive. If any one of these three parts is flunked, it violates the Establishment Clause. So, purpose, if the purpose is secular, then if the question is whether the effect is religious, and if the effect is not religious, then it has to, at that point, had to go through the entanglement prong. Get this. Now you'll understand why the current majority of the court, the majority 10, 15 years ago got rid of entanglement. Suppose what you want to do is fund private education, and you're worried about having some of that money that goes to private education with public education, some of that money going to religious education. So what you do, as a condition of giving money to private religious schools, is to impose certain conditions on their use of the funds. Hey, you can't use this for religious purposes at all. You cannot hire teachers for religious subjects. You cannot buy religious books, and you've got to file reports with us. And moreover, every so often, we're not going to tell you this, we're going to come by from the state, and we're going to check to see whether you're complying. And that's the entanglement part. When government was trying to avoid having its money go to private religious education or similar purposes, the Supreme Court said, hey, you've got the government too much entangled with religion there, and that violates the Establishment Clause as well. You see, damned if you do, damned if you don't kind of argument in the entanglement part or prong of the Establishment Clause analysis. That was subsequently eliminated and folded into the effects part, the second part. There's another test that Justice O'Connor brought to us, and that's the Endorsement Test, and that particularly involves religious displays, and that's somewhat less restrictive of government and religion. Here's the test. Would a reasonable observer familiar with the customs, history, and view, let me back up. Would a reasonable observer familiar with the customs and history of the community view the government conduct as endorsing religion? The reason for this test is to prevent a feeling of outsider status, and Justice O'Connor tried her best to be objective in setting out this test, an alternative to the Lemon test, but inevitably the objectivity, such as it is, depends on the characteristics of the reasonable observer. Reasonable Christian, reasonable Jew, reasonable Muslim, reasonable atheist, reasonable agnostic. what characteristics do you give to the reasonable observer? But it was a pretty good try. And finally, the last test, the least government restrictive, is Justice Kennedy's test in Lee versus Weissman. This was a middle school prayer case where attendance was not compulsory. Attendance was not compulsory for this middle school graduation at all, but there was a prayer given, a government-sponsored prayer, and the Supreme Court held that there was, in an opinion by Justice Kennedy, there was a kind of psychological coercion there, and that coercion rendered the government prayer in that situation violative of the Establishment Clause. Notice, even though attendance was not, strictly speaking, compulsory, there was a kind of psychological coercion on for these kids to be there. Notice, in connection with that Town of Greece legislative prayer case, to the extent you focus on psychological coercion, notice the implications where only adults are involved. Isn't there much less reduced concern, much more reduced concern, if you will, with psychological coercion in that situation, which was a factor in the Town of Greece case? So that wraps up, for the time being, this little summary of the Establishment Clause, and it brings you to where we are now in Establishment Clause jurisprudence. Now let's talk about the Free Exercise Clause. And the Free Exercise Clause is more obviously concerned with protecting religion from government. Notice what the issue is here. When a person is successful on his or her Free Exercise Clause claim, that means that person is exempt from an otherwise generally applicable rule of conduct. When someone makes a Free Exercise Clause argument, that person is arguing, saying, I want out of this generally applicable rule of conduct, which can be civil, which can be criminal. Okay? And we call this mandatory accommodation, where the government is required by the Free Exercise Clause to confer an exemption. Here's where I want to introduce you to that tension I adverted to earlier between Establishment Clause and Free Exercise. Some of you see this already. To the extent that there is an exemption for religion from a generally applicable rule of conduct, isn't that a preference for religion, and what happens to the Establishment Clause in that situation? Now, these are two constitutional provisions, and we're going to see the tension between them as we get into some of these cases that have come down recently. But before we do that, a brief history of the Free Exercise Clause. The Free Exercise Clause jurisprudence of the Supreme Court actually began way back in the 19th century with the Mormons in 1879, where Congress prohibited polygamy in Utah and other territories. And the Supreme Court upheld that prohibition against a free exercise claim by the Mormons, by individual Mormons. Upheld that on this ground. And pretty clearly that's a burden on the free exercise of religion of Mormons, who at that point believed in polygamy. The Supreme Court gave us a distinction, which I want you to keep in mind as we move through these other free exercise cases. The Supreme Court gave us a distinction between belief and action. You can believe what you want, but when it comes to action, if your action violates social duties or is subversive of good order, that implicate the Free Exercise Clause at all. Government regulation of such conduct, violation of social duties, subversive of good order, does not violate the Free Exercise Clause, so government, the United States, was constitutionally permitted to prohibit polygamy. Now, not much happened until the Warren Court with the Free Exercise Clause, and interestingly enough, it was some of the liberal justices, led in part by Justice Brennan, who said, wait a minute, that approach, that distinction between belief and action is unfair because government often does things, it often acts in ways that create a significant burden on religious activity, on religious behavior. What should we do about that? And the Supreme Court, in two cases in particular, Sherbert versus Werner, involved the denial of unemployment compensation because of refusal to work on a Saturday, which was her Sabbath. That was struck down as violative of the Free Exercise Clause, and a state law, Wisconsin state law, requiring students to go to public school beyond the 8th grade. That was struck down. Why? Here's the interesting point. Now we get into a little more lawyer talk. The Supreme Court in Sherbert and in Wisconsin v. Yoder used strict scrutiny. You all remember strict scrutiny. Government needs a compelling interest, but even if there's a compelling interest, the means must be narrowly tailored to the end in order to survive strict scrutiny. So in these two cases, in Sherbert and in Wisconsin v. Yoder, the Supreme Court backed off, if you will, of the Reynolds case from over 100 years ago, almost 100 years before, and said strict scrutiny. This next decision, Employment Division versus Smith, the Peyote case, that one came out of the blue. Hardly any of us expected it. A state criminal statute prohibits the use of certain drugs, some certain substances. Included in that list is peyote. However, in this particular case, a Native American ingested peyote for religious purposes. It was mandatory for him to ingest peyote, and the case went up to the Supreme Court, and we all expected an application of strict scrutiny in that situation. Substantial burden, are the compelling governmental interest? Well, drugs, yeah, narrowly tailored. Who knows? In what can only be called a revisionist decision, which was written by Justice Scalia. He was brilliant at writing revisionist decisions because he was so brilliant, period. He let stand Sherbert and Yoder, which used strict scrutiny, distinguished them on, shall we say, interesting grounds, but let them stand. And he said, the rule now, going way back to Reynolds, the rule is we use rational basis review, where there is no discrimination against a religion, even if a generally applicable rule of conduct, here criminal, involves or creates a substantial burden for a religious practice, it does not violate the Free Exercise Clause. I think he went even further as I read the case. He said, substantial burden or not, you're not involved in a Free Exercise Clause case at all. There's no Free Exercise Clause analysis you're doing there. It's rational basis that you are doing. So this exemption in the Smith case was removed, basically. There is no Free Exercise Clause exemption when you are challenging a generally applicable rule of conduct because of its burden on your religious practice. Now that's remarkable. Let's make this more concrete. What if a state prohibits all circumcisions that take place outside of a hospital and that are not performed by a doctor. Well, that will affect Muslims and Jews. What if a state, and the state says this for the safety, the health and safety of minor boys, little babies. Well, that's rational. That would be sustained, unless you can show it's a subterfuge for anti-religious discrimination. Okay. Or what happens if the state prohibits minors, all minors, anybody under 18, from ever taking any alcoholic beverage, including wine, for sacramental purposes. Flat out prohibition. Well, as I read Smith, that's rational, and that would not violate the free exercise clause. What does Scalia say to that parade of horribles? He says, look, the remedy is a political remedy. Fortunately, in this country, we don't have cases very often that involve those kinds of terrible situations. He also pointed out that under no circumstances should Smith be read as to allow religious discrimination. That's different. That's a violation of free exercise clause. But we're not talking about that, folks. We are talking about generally applicable neutral rules of conduct that create a burden on religion. And those are rational basis review. In a few moments, we'll talk about the congressional reactions to that. But now I want to get into the tension between the free exercise clause and the establishment clause with these examples, these cases. Locke versus Davey, a 2004 decision. There was a Washington state constitutional provision that prohibited any direct or indirect payment of money to any religion, a so-called Blaine Amendment, which I may get a chance to talk about later. Washington State had a program that awarded merit scholarships to college students, but excluded those pursuing degrees in devotional theology. In an opinion written by Chief Justice Rehnquist, nasty dissent by Scalia and Thomas, Chief Justice Rehnquist said, there is some play in the joints allowed between the Establishment Clause and the Free Exercise Clause claim. Here, Washington State had a powerful anti-establishment interests. And training for religious professions and for secular professions was not fungible. That's Locke v. Davey. I want you to notice what the student in Locke was seeking. Money was going to students pursuing advanced degrees in certain subjects, but not in religion. If he had won, get this now, that would have given rise to a free exercise clause duty on the part of government to fund, notice this is a funding case, to fund religion. That's how important this stuff is, literally to fund, an affirmative duty. Litigators on behalf of religious entities and individuals have been clamoring for that kind of finding of an affirmative duty to fund. But more about that in a moment, once I tell you about the Supreme Court's decision last term involving a similar kind of issue. That's the Trinity Lutheran Church decision, which dealt with a state program that provided funding for replacing playground surfaces with materials made from recycled tires. This was a Missouri, came out of Missouri, and Missouri had a state constitutional provision very much like Washington State's that prohibited the direct, indirect payment of money to any religion. Because the state excluded churches from eligibility for the grants, when Trinity Lutheran ran a state and daycare center with a playground located on church property, And what it did, it sought money for replacing playground surfaces with materials made from recycled tires. And by the way, the playground was used for kids in the religious school as well as made available for kids in the neighborhood after church services and after the religious school was done. They sued, and in an opinion written by Chief Justice Roberts, the Supreme Court held the exclusion violated the Free Exercise Clause, putting, I quote here, putting Trinity Lutheran to a choice. It may participate in an otherwise available benefit program or remain a religious institution. It's a refusal to allow the church, solely because it is a church, to compete with secular organizations for a grant. This was not a question of funding so much, but this was a case that therefore involved religious discrimination, and it triggered strict scrutiny, and the state's reasons, a policy preference for skating as far as possible from religious establishment concerns, cannot qualify as compelling. Now, so that's, the court obviously had to distinguish that Locke v. Davey case, but here's what's intriguing. There was a footnote, footnote 3, famous footnote 3 in Trinity. I guarantee it's going to become famous. This footnote was only joined by 4 justices: Roberts, who wrote the opinion, Alito, Kennedy, and Kagan. Here's what the footnote said. We do not address religious uses of funding or other forms of discrimination. And Justice Gorsuch, together with Justice Thomas, concurred in part, and they did not join footnote 3 because they thought that the limitation in this footnote, we do not address religious funding, they didn't like that. Here is the interesting question that is raised by Lutheran, by Trinity Lutheran. A state funds only public education. It does not fund private schools at all, and that includes religious schools. And now the claim is made that that violates the Free Exercise Clause because it constitutes impermissible discrimination against private religious schools. I think that's why footnote 3 is there. I think footnote 3 is what got Kennedy and Kagan to go along with the Chief's opinion, and that's what made Gorsuch and Thomas stay out of footnote 3. Just for the record, Justice Breyer had his own take on things. He concurred in the judgment, and Ginsburg and Sotomayor dissented, and they said, among other things, this is a remarkably disturbing case because it seems to be the first time we've allowed money to go directly to a religious institution. Okay? A bit overstated, but nevertheless, they were very concerned with that. All right, so that's Locke, and that's Trinity Lutheran, and now we're going to do statutes. And we needed to know about the Establishment Clause and Free Exercise Clause jurisprudence in order to talk intelligently about RFRA and RLUIPA. Remember that Smith case, the Peyote case, the big surprise. Congress was having none of it. So it enacted RFRA, an in-your-face challenge to the United States Supreme Court, saying, you say that as a matter of Free Exercise Clause, whenever there is a substantial burden on religion resulting from a generally applicable rule of conduct, you say rational basis review? We statutorily say strict scrutiny. Really going back, harking back to Sherbert and to Wisconsin v. Yoder. And you look at the language there, and you'll see that strict scrutiny language, compelling governmental interest, and least restrictive means. RFRA was struck down by the Supreme Court because it was so in your face. In the City of Bernie versus Flores, because the Supreme Court held it exceeded the scope of congressional power under Section 5 of the 14th Amendment, Congress was attempting to make free exercise clause law, but this is a judicial function. See Marbury v. Madison. Whenever you're in doubt, trot out Marbury v. Madison. And that's what they did. It's a judicial function. And incidentally, it is pronounced City of Bernie because some years ago I was talking about this decision to some federal judges, and I said City of Bern, and a federal judge meekly raised his hand and said, "Professor, it's pronounced Bernie." I said, "Oh, thank you for that. How do you know?" I was the federal district judge in the case. I said, "You got me. You got me. It's City of Bernie." However, even though RFRA is struck down as applied to state and local governments, it is constitutional as applied to the federal government through the necessary and proper clause, and the Supreme Court said that in the Gonzalez case, which dealt with the application of federal drug laws under the particularly the Controlled Substances Act, to a special sacramental tea of a small Brazilian sect. Okay, so it is constitutional as applied to the federal government, which means it's constitutional as applied, if you will, to something like the Affordable Care Act, which is a federal statute. The Affordable Care Act, which is always in the news. The Affordable Care Act provided that religious employers, such as churches, are exempt from the requirements of the Affordable Care Act. Religious nonprofit organizations that have religious objections are also exempt from the Affordable Care Act when they file a certain paper. And if they file that paper, more about that in a little bit, the result is that the insurer pays for the costs of contraceptives. But with respect to the Affordable Care Act and for-profit corporations, the Affordable Care Act says employers with 50 or more full-time employees must offer a group health plan or group health insurance plan that provides minimum essential coverage. That includes preventive care and screenings for women, interpreted to include FDA-approved methods of contraception, 4 of which may have the effect of preventing an already fertilized egg from developing any further. Hobby Lobby, a closely held family for-profit corporation, argued that this was a substantial burden on their religious belief, their exercise of religion, because in their view, life begins at conception. Now notice we're not talking about the free exercise clause, we're talking about RFRA and whether it applies, can be applied constitutionally, if you will, to Hobby Lobby. And the Supreme Court, and this was obviously another blockbuster, held that a for-profit, closely held corporation can be a person for purposes of RFRA, and the Supreme Court assumed that there was a compelling governmental interest providing contraception for women, but it was struck down as applied. It was struck down as applied because there were less restrictive alternatives available. Either the government could provide contraceptive coverage directly, or as suggested by Kennedy, it could use the form for exemptions for religious nonprofits. The substantial burden is not only on the belief that life begins at conception, but if they had to provide contraceptive coverage through insurance, it would add millions in costs. If they refused, there would be burdens, financial penalties imposed on Hobby Lobby. So, as a matter of statutory interpretation, which smacks of constitutional interpretation, but as a matter of statutory interpretation, Hobby Lobby has an exemption, if you will, an exemption under the Affordable Care Act. Now, what happens in a situation, this is a follow-up, when a religious nonprofit seeks an exemption from the contraception requirement and is required to submit a form for exemption? Does that requirement of submission constitute a substantial burden? Well, the argument was made in the Zubik case that if we even have to file a form, and even though the insurance company now has to pay for contraception itself, and we don't have to pay, we are being complicit in an act of irreligion. We are being complicit in a sin because filing the form triggers contraception coverage. That was the issue in the Zubik case, and this was a case that came before the court after Justice Scalia passed away and long before our new Justice Gorsuch took his seat. And that's why in Zubik, in May of 2016, the United States Supreme Court punted and said that we have the possibility of an agreement between the religious nonprofit and the government in terms of how to deal with this problem. So the court ducked the issue. Had Justice Scalia been there, you don't know what the result, I don't know what the result would have been in terms of this complicity argument, and I don't know what Justice Gorsuch would do or will do if the issue comes up, and it may not yet again. All right, let's talk a little bit about something that smacks both of free exercise and free speech, and then we'll finish up with RLUIPA, and we'll have a few minutes for questions. The Elaine photography case, this was a New Mexico case, as many of you know, which prohibited public accommodations from discriminating on the basis of sexual orientation. And Elaine Photography refused to photograph a commitment ceremony between two women, relying in part on the New Mexico Religious Freedom Restoration Act, a version of it's a state Religious Freedom Restoration Act. The New Mexico Supreme Court held that the photographer, Elaine Photography, did in fact violate the New Mexico Human Rights Act. There was a violation of the Human Rights Act. This was not compelled speech at all, because Elaine Photography argued we are being forced to say something with which we disagree for religious and other reasons. And the Mexico Supreme Court said this is not compelled speech. You still have your free speech rights to say whatever you want about same-sex marriage. But you've opened up for business, and you have to serve the public. That's what public accommodations are all about. And then the New Mexico Supreme Court held that the New Mexico Religious Freedom Restoration Act doesn't apply to private conduct, only applies to government, and there was no challengeable governmental conduct in this case. Which brings us now, and the Supreme Court, U.S. Supreme Court never heard the case, which brings us to a recently cert-granted case. Anybody heard of the Masterpiece Cake Shop case out of Colorado? I'll read a little bit from the cert petition. Jack Phillips is an artist. He has created elaborate custom cakes for over 2 decades. His cakes communicate the important celebratory themes of birthday parties, anniversaries. His faith teaches him to serve and love everybody, and he does. It also compels him to use his artistic talents to promote only messages that align with his religious beliefs. Thus, he declines lucrative business by not creating goods that contain alcohol or cakes celebrating Halloween and other messages his faith prohibits, such as racism, atheism, and any marriage not between one man and one woman. But Colorado has ordered him to create custom wedding cakes celebrating same-sex marriage wedding ceremonies. This mandate violates the free speech clause, compelled speech, and the commissions at the Colorado Commission's application of its anti-discrimination statute additionally targets his religious beliefs about marriage for punishment in violation of the free exercise clause. Fascinating. You see how that picks up from the Elaine photography case, but now we've got somebody explicitly and perhaps legitimately making an artistic expression claim. And there's more. This case is probably going to result in a decision in favor of Jack Phillips. That's my prediction, because get this now, and then we'll move on to our RLUIPA quickly, and then we'll get the questions. Get this one. The Colorado Civil Rights Commission did not apply its anti-discrimination statute to ban one, an African-American cake artist, from refusing to create a cake promoting white supremacism for the Aryan nation. That did not violate the anti-discrimination statute. An Islamic cake artist from refusing to create a cake denigrating the Quran for the Westboro Baptist Church. And 3 secular cake artists from refusing to create cakes opposing same-sex marriage for a Christian patron. Those did not, so says the cert petition, and it says that the Colorado Civil Rights Commission did not find that those violated any anti-discrimination laws. So, in a way, this is going to be an easier case than Elaine photography, because I think you've got discrimination on the record. And that may even give rise to a very straightforward free exercise clause claim, discrimination against religion here, but not in other kinds of situations. All right. Now let's take one last deep breath. Okay? We still together? Good. And now a few things about our RLUIPA, because RFRA was an attempted end run around that City of Bernie case. And remember, it did not work for state and local governments. The Supreme Court said unconstitutional. But our RLUIPA, dealing with prisons and land use, and many of you, I am sure, who do land use, must have gotten involved in our RLUIPA, because religious land use and Institutionalized Persons Act applies to state and local governments. This is a case, this is a statute involving not mandatory accommodation, which is free exercise, but permissible accommodation. That's what our RLUIPA does, and in a sense, that's what RFRA did as well. And our RLUIPA's language mirrors the language in RFRA. It's strict scrutiny stuff. So, and it's constitutional because it's not Section 5 of the 14th Amendment at all. It's the spending power, and it's the Commerce Clause. And our RLUIPA has been held constitutional and not violating the Establishment Clause as applied to prisons, and it is also within congressional power under the Spending and Commerce Clauses, as I have mentioned, although the Supreme Court has never really said that. All right. A couple of things about RFRA that I want you to know, real-world things. RLUIPA provides a private cause of action for appropriate relief against government. And in the Sossaman case, an inmate sued Texas and prison officials for not only injunctive relief, which is clear, but damages alleging RLUIPA violation. The Supreme Court held by accepting funds from Texas, by accepting funds from the federal government, Texas did not waive its sovereign immunity, and therefore Texas could not be sued for damages under RLUIPA. And the general rule with respect to individual liability, the circuits have held that RLUIPA does not create a private damages remedy against state and local government officials in their individual capacities. I have a Seventh Circuit case. If some of you want, during the break, I'll give you the cite to that. The only Supreme Court case involving the application of RLUIPA as such to a prison is Holt v. Hobbs, dealing with a Muslim inmate. He wanted to grow a half-inch beard in violation of the prison's grooming policy. Supreme Court held, that violates RLUIPA. Even if you've got a compelling governmental interest in regulating contraband, there are other ways of handling the problem, and the prison did not prove that other less restrictive alternatives were not available. Okay. I've given you a case involving RLUIPA from the Seventh Circuit. It's an interesting case which you will find useful if you do this stuff. Concluding observations, and then we'll open it up. There have been, as I indicated several times, dramatic changes in the past 20 years with respect to accommodation of religion in both the Establishment Clause setting and the free exercise promoting federal statutes, and in the Free Exercise Clause itself. Moreover, RFRA has been read expansively by the Supreme Court as it applies to the federal government. Hobby Lobby is a very good example of that. I fully expect this move to continue with Justice Gorsuch. See his views in the Trinity Lutheran case. Usually newly minted justices are reticent about setting out their views early on, but Justice Gorsuch has not been reticent at all, and he did that in the Trinity Lutheran case. And the big picture is always the extent to which religion is to play a role in the public square. We all know how important it is in the private sphere. The question is, how important a role should it play, is it allowed to play in the public square, including our political system? And we're still dealing with that issue, and we will always deal with that issue. I thank you very much for your kind attention.